Hello everyone. It is a true delight to welcome you to today's presentation, which is part of the CETA Hong Kong mini-course series. This is Adela Mao from Tower Chambers in Hong Kong. My topic today is collaboration with barristers in international commercial arbitration, how to build and work as an effective team. First of all, I'd like to set out the context of our discussion today and the purpose of today's mini-course. I want to start with three general observations, which I will invite you to agree with me. My first observation is that barristers are frequently instructed by solicitors' firms in court proceedings. My second observation is that arbitration differs from court proceedings, and while there is no strict requirement on instructing a barrister in an arbitration, barristers are still frequently instructed by solicitors' firms in arbitration, especially in those high-value and complex arbitration. My third observation is that there is an increasing number of Chinese law firms who are directly instructing barristers in Hong Kong. For those who are not so familiar with the concept of barrister or how a law firm works with a barrister or instructs a barrister, you might be wondering, what are the benefits of instructing a barrister? Why do law firms engage barristers in an arbitration? You might also be wondering, if you are convinced with the benefits of instructing a barrister in an arbitration, how do you collaborate with a barrister in an arbitration? And I would suggest that this course is made for you. For those who feel that they know the concepts of barrister, but who have not had the chance to instruct a barrister in an arbitration, I would say that this course would be of some value to you, because I will set out the typical work arrangement from a practitioner's point of view, and near the end of the lecture I will make practical suggestions to you. I will now deal with the first question, which is, what are the benefits of instructing a barrister in an international commercial arbitration? I think first and foremost, the factor that you should take into account when instructing a barrister, when deciding on whether you or not you want to instruct a barrister, is their specialist advocacy skills. Barristers are so-called specialist advocates in court proceedings, and their ability and skills in making advocacy, in terms of written advocacy as well as oral advocacies, are, in my opinion, transferable to an international commercial arbitration, but everything will depend necessarily on his or her experience in the field of arbitration, which is quite specialized from and distinct from the court proceedings. When you project the written advocacy, the concept of written advocacy into an arbitration process, it means that barristers can help with the drafting and settling of written submissions, reference schedules, and witness statements, and also the legal submissions made on interim applications, as well as before and after the hearing, what we call the pre-hearing submissions and post-hearing submissions. Why I say that I believe the technical skills are transferable to an international arbitration is because the usual work that we undertake as barristers in court proceedings include the drafting of pleadings, what we call pleadings in court, which include statement of claim, statement of defense and counterclaim, reply, and sometimes, only rarely, rejoinder. So this is something which we are familiar with, but please bear in mind that this is different from what we call a pleading style arbitration filing. As barristers, we are also trained in making skeleton submissions in court proceedings on various issues. We are accustomed to analyze difficult and complex points of law, and we are trained to make persuasive submissions to judges who know the law, and you try to convince them. Combine that all together, in my opinion, what we call the pleading style arbitration filing, the pleading style written submission, is something in the middle of a pleading and the skeleton submissions but the focus is on the pleading side, meaning you treat it as a pleading, but you vary it in the direction of a skeleton arguments, because necessarily you will include the evidence in the pleading style arbitration filing, and you will be making arguments, some of the main arguments in the pleading style arbitration filing. In the other style, which is memorial style arbitration filing, memorial style written submissions, my personal view is that it resembles more closely of a skeleton submission. And the task is for you to somehow modify it, somehow vary it in the direction of a pleading. When you can combine these two usual court filings and the skills deployed in making these court filings into an arbitration, I believe you will be a very good advocate in terms of written submissions in arbitration. And that's why I say that these skills are there and they are transferable to an arbitration, provided that the barrister you are instructing has had the necessary experience and insights into the field of arbitration. In terms of oral advocacy, the situation, I believe, is similar. You have heard a lot on the very trendy topic recently on the cross-examination, and I will refrain from making detailed submissions, detailed insights into the skills of cross-examination because of the focus of my mini course today. But in general, I want to also emphasize that part of the specialist advocacy skill that a barrister is supposed to possess in an arbitration or in a court is to make simultaneous, on-the-spot submissions to the judge, to the tribunal, to deal with the questions, to deal with unexpected circumstances, to deal with unexpected reactions from the witnesses. So in a way, we're trained in that. In terms of making opening and closing submissions, very interestingly, I think you have to adjust that because depending on the diverse background of an arbitrator who sits on the tribunal, you will need to maybe combine the usual style that you use in courts in making an address to the judge with the skills, some of the skills when you are making an address to the jury who are non-legally trained. So really depends on the background of the arbitrators before whom you're appearing. You can combine and balance the skills in reaching the maximum, the optimal performance in an arbitration. I also want to mention that many of the barristers speak native English or fluent English, and a number of them, such as myself, are native in Mandarin Chinese. So in a typical arbitration case where you have the proceedings conducted in English and you also have witnesses who testify in Mandarin Chinese, the language skills of the barristers can be relied on as an asset to the legal representation, because you should make sure that there's at least one counsel or lawyer on your team who can make simultaneous corrections to the transcript. And as I said before, instructing a barrister is not restricted to scenarios where you need to obtain advice on Hong Kong law. We are in fact frequently instructed in complex arbitration which involve different jurisdictions and which involve complex issues of law. These can be dealt with by expert evidence, because essentially when you have multiple jurisdictions at play, no one single lawyer will know all of the laws. And I would say you need to weigh the factor of their legal qualifications against the specialist advocacy skills that you see in this person as your advocate. My personal view is that you want to instruct someone who has the necessary skills and who can also deal with the legal points by way of expert evidence, because there's no other way that you can only rely on legal qualifications and expect that people naturally have the specialist advocacy skills, that will be putting the cart before the horse. In parallel and ancillary court proceedings, it is very usual to instruct the same barrister, the same sets, same team of barristers in the same all related proceedings, because he or she will know the facts inside out, and that will maximize the power of his or her submissions to the judge in the court or to the tribunal in an arbitration case. And that will be also potentially saving costs for the client. Next, we move on to what I call the special feature of the barrister's profession. Contrary to common perception, barristers are all sole proprietors, 个体户. We do practice in chambers. I practice in tower chambers. But chambers are not law firms, and barristers are not associates or partners in a law firm. The most significant difference is that by law, we are not allowed to share profits. We're not allowed to share our fees. We charge fees separately and independently for the work that we have personally done for a specific case. Chambers only exist for administrative purpose, and they are mainly there to share the administrative costs. This special feature has been reflected in the IBA guidelines on the conflict of interest, which has been frequently used, referred to, and debated in international commercial arbitration. And as a result, you do not want to be perceived as not understanding this special feature of the profession, where a significant number of international commercial arbitration community come from this background. And you do not want to be perceived as overreacting to scenarios where, for example, you have barristers from the same set of chambers who participate in the same arbitration, perhaps in different capacities. For instance, where one counsel acts as the barrister, as the arbitration counsel, and the other acts as an arbitrator. They may make declarations according to the IBA guidelines on the conflict of interest. However, in my personal view and also in my experience, you will seldom see any challenge successfully made on the sole basis that two barristers participating in the same arbitration who come from the same set of chambers. There can be a very simple structure of the counsel's team, of the barrister's team, in that when you have one barrister, he or she will usually be the one who's making the submission, making the oral submissions, and he or she will be the sole advocate in certain case. Or where the lay client's budget permits it, you may have a structured team of 3 counsel, which is very typical in complex arbitration. For example, you may have a Queen's Counsel or Senior Counsel as the leading counsel, who will be making all oral submissions and who will be settling and approving the works carried out by the junior counsel. You will also have 1 or 2 junior counsel who will assist the senior counsel, the Queen's Counsel, the leading counsel in an arbitration. As such, because of the sole proprietor nature of our practice, you may see different barristers working on the same team from different chambers. And when the circumstances combined, you may see different counsel at different stages of the same case, which is undesirable, but this may happen. For example, because of clashes in their diaries, when the case is run over a really long span of time, or when the case is overrun. The last point that I want to emphasize our work capacities. As a sole proprietor, a barrister only has limited time, and they may have multiple engagements at the same time, and they rely on the handling law firm to take instructions from the lay client to take charge of the day-to-day communication or management of the case. It will seldom be satisfactory if you have to rely on a single barrister to handle the day-to-day communication with the tribunal, with the other party, with the lay client in any single case. And it is advisable in those circumstances to consider instructing at least more barristers so as to increase the manpower. This is what I suggest a typical work arrangement in a typical international arbitration case. I have highlighted what I consider as the main scope of work. At all stages, the handling law firm takes instructions and collates evidence. Barristers are usually not involved in the day-to-day communication with the client. If there is a specific issue or need for clarification, the handling law firm will arrange for a meeting with all parties. This will be the norm throughout the process as the work develops. In addition, the handling law firm will be the primary contact in arbitration with the tribunal, the other party, and the arbitration institution. The arrangement of payment of money is in the exclusive arena of the handling law firm. Barristers are sole proprietors, and we do not have law firms' client accounts, and that is not typically part of our job. At the pre-action stage, the handling law firm will arrange to obtain preliminary advice on merits, and barristers will use the instructions received and evidence collated as the basis to provide preliminary advice. When the arbitration turns on some issue of foreign law, for instance, where the issue is the interpretation of a contractual clause which is governed by foreign law, the handling law firm may arrange to obtain a preliminary opinion on the foreign law. Barristers may be instructed to prepare a list of questions for the foreign law expert and to advise on the issues which we want to seek clarification from the expert. Depending on the applicable rules, you may file a request for arbitration or a notice of arbitration in order to commence the arbitration. Depending on the rule, this may or may not be followed by a specific statement of claim, or need to be answered by an answer. Even in complex arbitration, the first filing in an arbitration can be relatively brief and succinct, and the handling law firm may prepare the filing without involvement of the barrister at this stage. At other times, especially when you are hoping for an early settlement with your strong cards faced up, or you've obtained an ex parte injunction with the usual full and frank disclosure, you may insist on having a barrister to prepare a full and detailed version of the initial filing, which will closely resemble a statement of claim. That is why I use a square bracket to indicate that this is alternative. For the procedural orders, the handling law firm may sometimes prepare a draft set of directions for adoption, or that the tribunal may circulate a draft procedural order for comments. Depending on the complexity and importance of the issues to be decided in the procedural order, for instance, where parties disagree as to what language should be adopted for the arbitration, you may instruct barristers to make written submissions or oral submissions at the procedural hearing. The same applies to interim applications. Preparation of the drafts of the statement of claim, statement of defense, and counterclaim, reply, and sometimes rejoinder is the typical work undertaken by a barrister. It is advisable not to limit the barrister's work to only appearance at the hearing, because by then the parties' positions and the scope of issues are already fixed without the benefit of the barrister's input. The handling law firm will take instructions on the draft submissions. In other words, they will take the client through the draft in great details and confirm the contents. Similarly, barristers may prepare the draft witness statements, on which the handling law firm will take instructions. Sometimes the handling law firm may prepare the first draft of witness statements for the barristers to settle, meaning to make comments and revisions. In between the filing of defense and reply, or after the closing of these filings, depending on the procedural timetable set by the tribunal, the parties may undergo the disclosure process. The handling law firm may instruct barristers to prepare the reference schedules and make submissions if there are complex issues, or that they may prepare the documents themselves if their capacities allow that. Barristers will prepare the pre-hearing and post-hearing submissions and appear at the hearing. The handling law firm will also be present at the hearing such that they will assist the advocate. But before the hearing, they will liaise with the arbitration institution, the other party, and the tribunal for the booking of the venue, the payment of the fees, and for transcription services. After the hearing and upon the tribunal's direction, the handling law firm will prepare cost submissions, including cost schedule, and make comments on the other party's cost submissions and make replies. Barristers are not always involved at this stage, in particular in relation to the cost schedule, and their fees are usually claimed as disbursements without the detailed scrutiny that applies to a law firm's bill. Now I will highlight a few takeaway points. On the last note of typical work arrangement, although there is no hard and fast rule about division of work, barristers who are more familiar with the typical arrangement will perhaps harbor an assumption. If there is a departure from the typical arrangement, for instance, where the handling law firm will require daily input from the barrister, it is advisable to discuss and give prior notice. This may have an impact on the structure of the counsel team as well, in that it may be necessary to instruct more barristers to increase the manpower. The next point is that barristers may expect costs on account or advance payment from the lay client. That's part of the practice rules that govern Hong Kong solicitors. The last point is that barristers rely on the handling law firm to manage the client. When it comes to basic questions, for example, what the procedure is like, what a specific ruling means, the handling law firm is generally expected to communicate with the client without the involvement of the barrister. If there is a need for client counsel meeting, of course, that can be arranged. This is the end of my presentation. Thank you for watching. May I take the opportunity to thank CTAC Hong Kong for organizing the mini-course series. If you have any questions or queries, please contact me at the information below. Thank you.